guys, welcome back to the channel where I cover missing persons, unsolved cases, crime news, and more. Well, there has been a hearing, a Supreme Court hearing in Massachusetts. It happened yesterday, which was Monday, January 6th, in regards to why a Massachusetts judge placed Harmony Montgomery, who was 4 years old at that time, in the custody of her biological father, Adam Montgomery, who, as we know, had a violent criminal history with many convictions. So they have been hearing it, and as of right now, there is no decision, so I'm going to play part of it that Court TV has posted. Basically, the Supreme Judicial Court heard arguments on whether the press should be allowed to access a transcript or audio recording of a February 2019 hearing where a judge placed Harmony into the custody of her father. Now, the case actually stems from a request by journalist Bill Lichtenstein of LC Media. He is seeking access to an audio recording of that hearing, which was held in Essex Juvenile Court. And in that particular court, proceedings are shielded from the public, which is usually the case when it comes to family services, that sort of thing, with juveniles. He is seeking access to it on the grounds that the public interest in the case is such a great, it's so great that it super exceeds the privacy protections in place with the court. Now, a lower court denied his motion, so he's taken it to the state Supreme Court, which is the highest he could take it to in the state, and they are hearing the appeal. And we are going to see what happens. This is a big deal because obviously, as we know, this judge caused Harmony's death. I have no question in my mind. And I think the privacy concerns, well, Harmony is deceased. Sadly, we still don't have her remains, and where they were searching last year, there have been searches, but I don't know if they're ever gonna find anything, considering the conditions that she was last known, her remains were last known to be in. Her father, well, sperm donor, he doesn't give a crap. Of course, he's in prison. He was moved last year due to, he was beat up, and his head was pushed down a toilet bowl. So he's been moved out of state, and guess he got some of his own crap, huh, guys? And the only one who is really protesting it is her mother. So at this point, she's saying it due to privacy and what have you. I wonder if it's because she's trying to protect her own butt. So let's listen into a bit of it. As you guys know, I'm not a legal expert, but I will state my opinions. And if any of y'all know, legal stuff, if you can understand the stuff more than me and you love to comment, I would love to hear your opinions, and of course everyone else's as well.
We must not allow public institutions to hide behind the privacy rights of individuals in order to evade public scrutiny and critique. In this particular case, and under the specific facts of this case, the lower court judge abused her discretion by failing to properly balance the privacy interests, whatever those may remain for this family, against the public's right to know exactly what happened in a proceeding that led to a child being placed in the custody of her eventual murderer. LC Media came before the lower court seeking, using the Uniform Rules of Impoundment standard, and alleging that he had good cause to seek release of the specific audio that resulted in the hearing that granted custody to the father in this matter. While it is certainly true that, pursuant to its statutory mandate, the Office of the Child Advocate produced a detailed report, it is unquestionable, and that report itself was a summary of information that the OCA determined to be relevant and necessary in order to inform the public.
I agree with you that obviously the most important consideration is trying to figure out what went terribly wrong here. Is there anything that shouldn't be turned over? I mean, are there any residual privacy interests that we have to take into account here, given that? I mean, I'm trying to understand, is there anything that should be impounded in your view?
Well, as you're aware, Justice Kafka, we've had no access whatsoever, so I can't specifically point to a particular statement by counsel during that proceeding that would reveal something that is not already out in the public domain. But as I'm sure the justices are aware, when we brought this motion, we specifically requested from the lower court judge that she exercise the broad discretion that she has to limit, if there is indeed information that the public does not already have, that could be limited in when the disclosure is made. So names could be redacted. This is a case that, it goes without saying, has had enormous public exposure, both nationally and internationally.
How does that factor into? I didn't see that as something to be considered in the factors the judge was to consider.
Thank you. I would say it has to be considered because the nature of the public interest is part of the standards under the URIP.
But the nature of the public interest may be, but the quantity of public interest that's already occurred doesn't seem to me to be coterminous with that first factor.
It's certainly not a deciding factor. The fact that you could have an equally serious case that for some reason had not received the same level of press attention, and I think you could still meet all of the other factors.
Okay, so again, why is that then? Why is the quantity of attention relevant?
I think it's less the quantity of attention, but the content of the attention that goes to the privacy interest that Justice Kafka was just questioning.
And by that, do you mean just the subject matter at issue?
Well, the subject matter at issue, but certainly the fact that it appears clear that the underlying statutory scheme for privacy under Chapter 119 is to protect children and families involved in these type of proceedings from the stigma attached to having parents with substance abuse issues, parents who have perhaps performed appalling acts to children, and to protect them from that. In this particular case, the mother herself has freely discussed the substance abuse issues that led her to lose custody of her child. The father, who one would think would have some objections to disclosure, has not objected to disclosure at all. The Department of Children...
Adam hasn't objected because he doesn't give a crap. He doesn't care. He claimed to care about his daughter, and then when he went to trial, you could tell he's a piece of garbage. He is a piece of garbage. And the only reason I think Crystal cares is because she thinks it's going to make her look even worse. But Crystal, we already know you have this past, okay? And we also know that you've lied. So I don't know what else besides getting accountability, which is essential to prevent something this horrific from happening again to another child and another family, from happening again.
Children and families, while they argue strenuously against any sort of waiver of any of the privacy interests, I would respectfully suggest that the design of the statute is not to protect the government agency that's operating.
Do they have any privacy interest, the DCF? I mean, I understand how the mother can have a privacy interest, the father, the children, and maybe even the adopted siblings, but DCF has no privacy interest, right? Whatsoever.
I agree with that. I agree with that completely, Justice Kafka. While the department has, in this case and in others I've argued, asserted that the names of the social workers, for example, should be kept private because they're considered under Section 38 of 119 names of the parties. I dispute that. I don't think the names of government actors in the course of their public employment constitute a privacy interest. Certainly, none of these proceedings involve personal facts about the individual social workers.
They do in the sense that the Office for Children finds fault with at least one of it finds fault with DCF. I'm not sure the individuals they find fault with, right? But
well, I think we all find fault with the judge. He's the main problem. But these workers, they need to be held accountable as well. I mean, the report was very, very clear on that. I don't think in these sorts of cases that these social workers, these case workers, if they are involved in something that they could have prevented in some way, that they should have their names sealed off to the public. I think that they're in a line of work that they are a public, they should be known by the public. It's the same thing that happened in the case of little Tommy Valva out of New York. You know, these workers need to be accountable as much as the judge does.
That report finds fault with DCF, correct?
Yes, that
And
report.
particular individuals of DCF?
Well, the report specifically criticizes counsel for DCF for their lack of legal argument and motions practice in terms of highlighting the department's position in that case. So I suppose technically that's a specific individual at DCF as opposed to the agency as a whole
So
that
they
would be
might
identified.
so they might have some privacy interests. Or maybe not. I don't know.
I would certainly hesitate to suggest that a government employee who, by another oversight agency, has been accused of not having performed their duties diligently and appropriately has a privacy interest in protecting public exposure. That's exactly how the public and the press, through that conduit, and the legislature inform themselves over what reforms are necessary. And I wish to be clear, of course, that this is a case based on these facts, just as MC requires. There must be a factual analysis of this specific case. We are not seeking to reform the entire system. We are seeking to inform the public and the press and the legislature, who has been asked by the OCA report to consider a number of recommendations that would completely alter, for example, the child-directed advocacy model that currently exists for CBCS. We are taking the position that the OCA report, while lengthy...
You are seeking to reform the system, right? That's a big part of your brief, is that you feel the investigation here will improve the system and correct the errors that were made, correct? So that we don't do this ever again, or we do whatever humanly possible to avoid doing this again.
There are systemic changes that need to be made. There are seismic shifts that need to happen in the entire juvenile court model. There's no question about that. But this specific case...
Yeah, the justice is correct. This is what needs to be done. So Harmony's case is sort of it's a horrific example of how horribly, horribly wrong the system has been and can be for these helpless children. So yeah, it's an example, and hopefully, more than hopefully, it needs to happen, and not just in New Hampshire. It needs to happen all over the country, that there needs to be a reform and the system needs to be better.
Nobody knows, not the legislature, not anybody outside of the parties themselves and the OCA knows what exactly happened during that hearing that resulted in the court granting custody. And the OCA...
Is that the extent of your request at this point? Because I thought you were requesting, there was an August 2014 temporary custody proceeding. There was a July 15th trial, 2015, December 2018 hearing where the judge issued the request for an expedited interstate compact on the placement of children report. And then there is the February 2019 review. Which of those four, or all of those four, what are you looking for?
My client initially filed his motion pro se, but was specifically seeking access to the audio for the February 2019 proceeding.
Okay, and that's the limit of your request at this point?
At this point, and again, the judge has given broad discretion to craft an order that shields any potential private information that may still be out there. I don't know what it is. I don't know.
But let's go back one. I mean, you're alluding to the judge's broad discretion to craft whatever parameters might be necessary. But if you go back a few dominoes, the judge has discretion to allow your client's request for access or not. And that is subject to an abuse of discretion standard. You started off your argument by saying the public's right to know. So there's really not a right to know here. There is a process by which you can seek to have some access, and the judge, my concern here is you have an abuse of discretion standard. There are certain factors that were weighed in ways that you perhaps disagree with, but does that rise to the level of an abuse of that judge's discretion, or are you asking us to substitute our judgment for the trial judge's judgment?
I am not asking you to substitute your judgment. My suggestion is that the lower court judge did abuse her discretion in two specific ways, in a number of ways that I take issue with, but two that I think are quite specific. First, there is no real analysis in the judge's decision of the actual privacy interest at stake here. There is a passing reference to perhaps the privacy interests of other children that the mother may have. And of course, everybody, while arguing this matter below, kept referencing Section 38 of Chapter 119, which says it shall be unlawful to publish the names of parties to these proceedings. Mother's subsequent children are not parties to these proceedings, so that would not have protected them. So I found the judge made no specific finding as to what privacy interests remained and how those privacy interests would be affected by disclosure. I believe that was an abuse of her discretion. She was required to do that. I would further add, Justice, that one of the other things the judge was supposed to do was to balance the interests at stake.
This is the second way the judge.
Yes.
Okay.
Yes. And the second, the judge was supposed to, was required to evaluate the constitutional rights that were at stake here.
You're not in trouble. Nobody said you're losing your daughter. Okay? So I want to make that clear. So you know, I have a body tomorrow, just like everybody else is being on your report. So you just need to find out where she is. That's all I'm concerned about. I mean, you're not in any trouble right now that I know of. Okay. You have no warrants. Okay. So where's your daughter so we can check on her to make sure that she's okay? Right now, I have nothing to say. But that's not what I'm just asking where she is. I have nothing to say. So you don't care if your daughter's okay or not? I do. I listen, I have nothing to say.
And that's Adam, remember, when they located him living in his car with another girlfriend, who's also deceased. Seems like people that get around Adam are dead or in jail. And of course, he has nothing to say. The piece of crap that he is. And it is just sad that Harmony had to live her final days with this monster. And it didn't have to happen that way if this judge didn't give custody to her father.
I think there cannot be an argument that state-conferred confidentiality via statute trumps the United States Constitution. And the court in this case specifically dismissed any idea...
What constitutional right are you relying on? Because you concede in your brief that you cite a bunch of criminal cases, which is a very different calculus than a civil case here. So what constitutional right are you relying on?
Well, I would first say Richmond News is the first one that comes to mind, of course. Richmond News did involve a criminal case, but as I'm sure your Honor is aware, throughout the decision-making, there were a number of concurrences. The justices specifically keep going back to the First Amendment and to the 14th Amendment. They do not rely on the Sixth Amendment. And then there's a line of case law from that.
But criminal cases historically are open to the public, whereas these cases are not.
These cases are not historically.
So can you address for me why that analysis doesn't matter in your estimation?
I am not suggesting that, like criminal cases, every juvenile juvenile court case should be open to the public. I'm not asking for a blanket rule that applies in criminal matters.
No, but you're arguing on the constitutional prong of that Rule 11 analysis, and I'm wondering why you're equating access, the right to access to these proceedings, which historically has not been allowed, with those in the criminal proceeding.
So there is an extensive line of cases referring to both civil and criminal matters that discusses the fact that the right to speak implies a right to listen. The right to freedom of the press implies a right to gather information. There is an excellent quote by Justice Stewart in his concurrence in Richmond, where he essentially says, we don't expect our public institutions to be fallible, but it's extremely difficult for the public to understand that which it is not allowed to observe. I think particularly taking into account the URIP factors that exist here, there is a constitutional right of the press to access.
How do we measure the community interest prong of MC? It seems to me that this is a case that would, of course, ordinarily be private and unsealed. And what makes this case different when you go through the factors is the level of community interest. How is a judge to measure that?
Well, it is certainly within the judge's discretion to do that, and I think that that's part of the balancing test. Well, I think that's part of the balancing test that didn't occur here, is to say, so what is the level of community interest? In this case, the level of community
is it if the local paper
incredibly high?
Yeah.
Is it if the local paper wants to write about it, or is it how is this measured?
Right.
How is it applied?
I think it requires a number of different factors, one of which, for example, is it just the local press? Is it the Lowell Sun reporting on this? Or is it the Washington Post? Is it a number of different media outlets?
It shouldn't matter whether it's the Washington Post or the local newspaper. It's got to be based on the fact that there's been a terrible governmental error here, right? That's what provides the constitutional. This is a different case. It's not an ordinary juvenile case. There's been a terrible error that's resulted in the death of a child, and the public has a right to understand that, right?
I agree with this justice. This is Scott Kofker. I agree with him completely. And by the attorney, I don't agree with her, and he doesn't either, when she says, oh, if it's small media, or God forbid YouTubers want this access, maybe it shouldn't be. That should not be the criteria. It needs to be accountability, okay? And there's not accountability in this case. And we're seeing more and more of these. And this judge is retired, but he's still working on the bench on the side as a substitute judge. So why are these people who are supposed to be protecting these children who are born into these drug-addled, criminal families, okay, why are they not being treated as well as everyone else? So Harmony had a loving foster family. Harmony had her brother Jameson's new fathers who wanted to adopt her. There was zero reason whatsoever that Adam should have ever been granted custody of her.
It's not whether the Washington Post or the Lowell paper is interested. It's the government's made a big mistake here, and we got to figure out why.
Oh, I agree with that, but I was specifically responding to Justice Gaziano's question, does it matter if it's just the local paper? And I'm saying,
why should it matter if it's national or local?
If no one knows about it, respectfully, if no one knows about it except for one member of the family who attempts to get public attention, and that person seeks to generate public interest to highlight this horrific act that occurred, that could be sufficient in terms of community interest.
Can I
Yes.
just want to make sure you keep saying that there were things that the trial judge didn't do. So why isn't this more of a case for remand than it is for this court to order access? You keep saying she didn't balance the community interest. She didn't balance the constitutional concerns. All of these different things that you claim the judge did not do. Why isn't this a remand case then?
It could be a remand. That's certainly within your authority to do, to remand and to ask the lower court judge to actually balance the freedom of access that we are alleging is part and parcel of the freedom of the press that is protected under Article 16 and the First Amendment. You could certainly remand it to her to do that, but I think the facts just within the four corners of the judge's decision are also sufficient for you to determine an abuse of discretion was made and a clear error was made and issue a different decision.
I don't know if I follow that, because if I marry Justice Wola-Hochin, Justice Kafka, and Justice Gaziano's concerned about what's the limiting principle here, because there are a bunch of these different factors, but you seem to be arguing that the first among equals is how much people want to know. And there are plenty of awful cases where children get hurt or they die in DCF custody. And so what makes this case different, that this is the case that we should say you get access because this is the one everybody wants to know? But if it just happens to be the next tragic case that...
I would like to hear what the attorney has to say, but Justice George is here. He's correct. What is it to say other cases? And there's many horrible, horrible failures. My thinking is there needs to be these examples. There needs to be a case like Harmony to make sure the justice system, that the state, all these people who they need to be held in check. They need to make sure that the children's best interests are happening. And it's just not the case. I mean, we're seeing way, way too many. I mean, you could name off all these names besides Tommy Valva and Harmony Montgomery. I mean, there's just so many. It just makes you sick. I mean, there has to be a case or two that really come out and show how clearly these judges and these workers are failing.
No one knows about, that somehow that doesn't factor in and militate in favor of disclosure, but this one does. And this factor is more pronounced and more dense than all of the other factors. How is the judge supposed to do that?
Well, this case is profound. The Office of the Child Advocate specifically found there are certain cases that come before the Office of the Child Advocate in which it is determined the public has a right to know. The case cries out for further explanation. And the OCA in this case took that, assessed it with that same level of seriousness that we are assessing it with, and determined that the public had a right to know. And I wish to be clear, I am in no way implying any bias on the part of the OCA, or that the OCA was in some way trying to shield a government agency. But when the public and the press and the legislature are informed by a single individual's distillation of what they consider to be the important facts, that is the opposite of the right of free access. That is a way to infringe upon the free press, as opposed to a way to ensure that it is robust and given the level of the ability that a public requires in order to be informed and in order to inform their own legislature.
So that was just a bit of the hearing. And I think that it's very, very important that these Supreme Justices hear this case. But I completely understand the questioning of why Harmony's case, why hers, and why not little Johnny over there, or whomever. They're all important, every single one of them. It doesn't matter how well known the child is, or how big of a media attention or public attention that they have. They all need to be treated the same way. But unfortunately, that doesn't happen, as we know. I mean, these missing children come up, like as Harmony has been, and some get more attention than others. I mean, it's one of those things. But as far as the Child Protective Services, Family Services, and the judges involved in these cases when it comes to giving custody of these children and making sure that they are safe, I think that there needs to be tremendous transparency. And yes, there is concerns for the privacy of the children and their families. I get that, but the fact remains is it should always be number one. The child should be number one. And it's just not happening these days. I mean, it's not happening. You can't open up the news and not see, at least, I don't want to say every day, but at least once a month or every couple months or so, another child who has been abused or worse yet, murdered by someone in their family because they were in the custody of their parents, they went to a foster home, whatever. I mean, there's just so many failures that there just needs to be this accountability, there needs to be transparency, and yeah, there's a lot to discuss because I don't think it's black and white at all. And I like that they're having this discussion, and I'm really hoping that they allow this audio to come out. As far as redacting certain things, I mean, I'm sure that can definitely happen. I don't know what portions would go to that extent. I don't want to speak for Jamison's fathers, but I believe from what I've read, I think they are all for all this to come out. They want the truth. They want their son and the sister of Harmony to be able to have that truth and that clear information out there about what happened to his sister, his big sister, because this never should have happened. We all know that. So again, I think while it is a hard situation, a decision for the Supreme Court, I also think it's also simplistic in a lot of ways. But I am very, very curious on what they're going to decide, and I'm hoping that we get some more clarity, because it just needs to happen. But let me know what you guys' thoughts are, because I know a lot of you also have followed Harmony's case, and she has just taken all of our hearts, and she has the justice, and her father is in prison. Kayla's a whole nother story, and Crystal got her lawsuit, and that's been amended. I'll have to go over that in another video. But as far as justice for Harmony, I think it needs to continue because she doesn't have complete justice. Yes, the one who murdered her, yeah, he's behind bars. Okay, but who else caused that to happen? It's a domino effect. And it started with the Child Protective Services and that judge. All right, guys, I hope you have a great rest of the day. And most of all, stay safe.